Okay, if everyone will grab a seat, we'll get started. On behalf of President Courtway, who could unfortunately not make this event due to the funeral of a UCA student we lost last week, and on behalf of the UCA community, we are delighted to have the Arkansas Supreme Court Justice here today to address our campus. The Supreme Court's visit here earlier today and Justice Hanna's willingness to speak to us this week is very timely. This is AVID Week here at UCA, a week which we are celebrating our condensed mission statement at UCA. As you may have noticed, there's a lot of signs that we've been put up in buildings and have delivered to offices around the campus that say UCA is dedicated to academic vitality, integrity, and diversity, therefore AVID. We want this not to just be a sign, but to be something the entire UCA community embraces and understands that this is what we stand for. Earlier this week, we had a panel on academic vitality, and earlier today, here in this very room, we had a panel on diversity. This session will address integrity, and we hope everyone has enjoyed the sessions, and we look forward to doing AVID Week again next year. There are free AVID material in the back. You see that where the refreshments, the cookies, and the punch. There's signs, there's some cups, and some buttons and everything. Please take those items back to your office if you would like. With that, it's my honor and pleasure to introduce our speaker here today, Chief Justice of the Supreme Court, Justice Jim Hanna. After graduating from Harrison High School, Justice Hanna attended the University of Arkansas and the University of Arkansas School of Law. He has been a city attorney for multiple municipalities in Arkansas, as well as serving as a deputy prosecuting attorney for Woodruff County. He's also been active in private law practice and has served as an instructor at Harding University. His judicial experience included being a city judge, juvenile court judge, chancery probate judge. He served in the 17th Judicial District and was an associate justice in the Supreme Court until serving as Chief Justice, which he has done since the year 2005. Justice Hanna is a member of the Arkansas Judicial Council, the Arkansas Bar Association, and numerous other legal associations nationwide. He's married to Pat Johnson Hanna, has 5 children, 13 grandchildren, and 1 great-grandchild. With that, please welcome the Chief Justice of the Arkansas Supreme Court, Justice Hanna.
I had to correct him the last time he introduced me the last hour. He just had me with 11 grandchildren. We just had twins, so and they're pretty special. As I say, these grandchildren they're better than real kids, and some of you are not old enough to realize that, but you will. It's my honor and pleasure to be here, and I want this to really kind of be a conversation, because I find that you know what you're interested in and what you want to ask, and I will try to answer them as best as I possibly can. I think that way you can benefit better from my time with you here today. The reason we're here today, we had oral argument here at UCA on the UCA campus, and it's a program that we call Appeals on Wheels. And I do take credit for that, but I came up with that. But it's a very successful program, and we're excited about it. We're excited about being here. It gives a chance for the people, the citizens of Arkansas, to see the Supreme Court, see how we work, how the third branch of government functions, and so it's very, very important. And as well as we do take the opportunity when we visit in the various towns and cities throughout the state, we go to the schools and to visit with the students there. So it's an exciting program, something we're very excited about. And I'll tell you how it kind of got started. That we're very concerned about the lack of knowledge of the citizenry about the government and how it works, how it functions, and how it should. And oftentimes when you see criticism, which we see a lot of today, a lot of it's just a basic misunderstanding about what it is, what role it is that the legislature plays, the executive branch, and the judicial branch. And things we're seeing are exactly, if you've all read, if you haven't, I would suggest that you read it, the Federalist and the Anti-Federalist papers, which were written back in the late 1700s for and again the Constitution, that great compromise that we had. One of the compromises that came out of that was the independent judiciary that we have, which is very, very vital, very important for our government to function. But the main thing, the message I want to bring more than anything else is not only the understanding of what the government, how it functions, and I think this speaks pretty clearly. I'm jumping around a little bit here, but there's a lot of polls that are out there, and there is one poll that always struck my attention, and all the polls I've seen give the same answer. But nationwide, there was a poll to adults. The question was, name the 3 branches of government. They were given, you'll be surprised, they were given multiple choice answers. And 51% of the people chose the 3 branches of government. Remember, this was multiple choice, was the Republicans, the Democrats, and the Independents. Now that's funny, but it's really not funny. It's a sad, sad comment on our public and what we're doing with civic education. We feel very strongly about that, and in the court, we feel like we've not done a good job of educating the people about what it is that we do. We feel all the studies show that where people understand how the government functions and how it works, they become more and more supportive of our government. And I do think we have the greatest government in the world. I believe that. I believe we have the greatest judiciary in the world. But if the people don't understand it, we could lose it. And I feel that could happen very easily. The courts, we can't function. We can't function. We get orders all day long. But if the people, we don't have the support of the people and their confidence, we can't function. And the same could be said for the other branches of government. It all comes from the people. That's your Constitution. That's what you gave the government, how they operate and function. Again, if you've got any questions, I'll try to answer them as best I can, and just raise your hand. I'll try, and we'll go from there. In Arkansas, we have 3 branches, or 3-tier system of courts. We have the district courts, which there's 125 of them. They're elected. All of our judges are elected. They're elected in a nonpartisan. Up until the year 2000, we elected judges Republican, Democrat, or Independent. And after the year 2000, we now run nonpartisan, which means we don't run as a Republican or as a Democrat. The district judges set without a jury. Most of them have county-wide jurisdiction. We have different levels of district judges. Some of them are part-time, and some of them are full-time. But they hear cases that involve, again, without a jury, they hear cases of misdemeanors where someone can be put into jail for a crime up to a year. They hear civil matters which can be disposed as measured by damages. If it's a part-time judge, up to $5,000. If it's a full-time, up to $25,000. They also hear the traffic cases. Now, I've said many times that's the lowest court we have, but it is also the most important court that we have, because that court sees more people, deals with more people than any other court by far. More people have contact with that court. And the contact you have with that court, that district court, whatever court it is, whether it be the court, the clerk you're dealing with, that's the impression you have of the judicial system, the justice system in the state of Arkansas or any other court. So that's where, if we're doing our jobs, people are treated as they should be on a fair, equal basis, and respond to their problems and their needs, treated with courtesy as everybody should be. That's where we begin to get the people that understand and appreciate and support what it is the judicial system does. Still not seeing any hands. If a person's not happy with that decision, in the district court, they have an absolute right to take an appeal. An appeal is, what that means is somebody else is going to review that decision of that court. Those appeals are taken to our circuit courts. We have 121 circuit judges in the state of Arkansas. They hear those cases that are appealed from the district courts. They have a jury, and they'll hear those appeals from the district courts. We call it de novo, which means it's like it never happened before. You get a new shot at it. Those circuit judges, again, they're elected nonpartisan. They're elected to a 6-year term. And they hear not only those appeals from district courts, but they also hear those cases that involve, in a criminal matter, any felonies, someone that can be sentenced to up to death in the state penitentiary. Hear all kinds of civil matters where wrongs can be measured in money. The sky's the limit in Arkansas, pretty much. That's another topic about punitive damages that's being addressed, a hot topic. Punitive is basically damages that can be awarded when there's an intentional wrong that's done to hopefully would prohibit that conduct from going on. But there's a lot of discussion going on in that particular area. They hear the adoption cases, custody, divorce cases, probate matters, commitments to state hospital. They hear those matters. Now, if a person's not happy with the decision that's been made in the circuit courts, you can take an appeal. You have an absolute right to take an appeal, and that's called to the appellate courts. And the appellate courts, what they do, we have 2 appellate courts. We have the Court of Appeals, and there's 12 of them, and they're elected to 8-year terms. Again, they're elected nonpartisan. They're elected from geographic areas of the state, but they have jurisdiction to hear cases from the entire state. Now, they're housed in the same office we are building in Little Rock. And there's also the Supreme Court, which I have the privilege of sitting on. There's 7 of us, and we run statewide, again, nonpartisan, for 8-year terms. And in Arkansas, we're one of 5 states in the nation that actually the people elect who their Chief Justice is. If I can name them, I know Texas, Alabama, North Carolina, Montana, and there's another state, I can't think of it right offhand, but they actually elect their Chief Justices. All different ways judges are elected and are appointed in the country. But the Supreme Court is the highest court in the state of Arkansas, and we determine what the law is in the state of Arkansas. The cases that we hear cases that involve the death penalty, life sentences. We hear cases that involve elections. We hear cases that involve taxes. And unfortunately, we have to hear from time to time cases that involve disciplinary actions on lawyers and judges. And we also hear cases of what's called cases of first impression, which means those issues have never been decided before. And it's hard to believe, but as long as this state has been in existence, lawyers are very innovative, and they come up with some good ideas that they present. But we hear those cases. The Court of Appeals hears all the other cases, including appeals from the workforce, the workers' comp, and cases from the agencies. We have a right, the Supreme Court, to review what the Court of Appeals does. We can review their cases to see whether or not we think they've made a mistake. And we will be asked to do that in several of the cases by the lawyers that are not happy with the Court of Appeals decision. Roughly 18% of those cases we will take and look at. That doesn't mean we're going to reverse them, but we do have that ability. We try as much as possible to make that Court of Appeals a court of last resort. A lot of times they'll certify cases to us that's got to them, and it develops there is an issue that's never been decided before, and they'll send it to us to decide. That's how our cases are heard and handled. No questions yet? I'm not doing that good a job. Yes.
You said something about
What we do, we don't write the law. The public policy is something completely within the bailiwick of the legislature to make. We're called upon to apply the law that has been by the legislature, a statute, and how we see it how it applies to a question of fact. It is the legislature's, we're all guided, we're all under the same document, the Constitution. And the legislature can do only those powers that the people have given them, and it's in the Constitution. We can do only those things that the people have given us, and it's limited as to what we can do. Same with the executive branch. So we operate under the Constitution. Sometimes, it doesn't happen very often, that perhaps a law is passed that violates what the Constitution provides for them to do. And sometimes we're called upon to address it. That doesn't happen very often, That's called review. And that's the checks and balances that we have, which has served us so well. The other thing is in the Constitution, if there's an argument as to what it means, then the courts are called on. It doesn't happen very often. What does that Constitution mean? And when we determine what the Constitution means, just like a statute, when we decide that becomes what that law is, that becomes part of the body of law. And that's when we interpret what the Constitution says in some areas. That's what it comes. If it's a statute, the legislature may come back and say, "Wait, we didn't really mean that. That's not what we meant. Was not the intent. Or certainly we didn't think about that for whatever reason." And and on a statute, they may come back, and this has happened. They will change it. This is not what we think the public policy should be. So that happens not very often, does it, Senator? But that's basically what I was talking about, and that's the body of a lot of the discussion that was in the Federalist and Anti-Federalist papers, and same things that you hear at the same time. But that's kind of the basic of how we operate. We're limited. We're guided by the Constitution. Justice O'Connor made the observation. I think she was exactly right when she said a lot of these decisions, whether it's constitutional or not, is made on a daily basis by your city councilman. Can we do this or we can't do this? Legislature makes that call all the time. Can we do this? Can we not do this? I mean, they make those. Most of those decisions are made there. We're not called upon to do that very often. Thank goodness. Okay, does that answer your question? Okay. Anything else? Senator?
How do you view the nonpartisan approach to the election? Do you have a thought on how that's impacted the judiciary in Arkansas?
Yeah, I hate to admit, I was first elected as a trial judge, a circuit judge in 1978. And back then we ran as Republicans and or Democrats or independents, mostly as Republicans or Democrats. And in the year 2000, well, the first time I ran for the Supreme Court, we still ran on a partisan basis, Republicans, Democrats. And so I was the last person to be elected in a partisan election. Now, I've always believed, and I still believe, party politics has absolutely nothing to do with what we do. It has nothing to do, and shouldn't have anything to do with what we do. Regardless of what party you come from, you've got a job to do, and you do it, and that just shouldn't be involved at all. In 2000, we passed Amendment 80 to the U.S. Constitution, or to the state Constitution, sorry. And it provided a lot of things. One of them which allowed us, we couldn't hold court outside of Little Rock until we passed that amendment, and now we can hold court outside of Little Rock. The last time we had, before the passage of Amendment 80 in 2000, we had, last time the Supreme Court of Arkansas held court outside of Little Rock was, as some people would say, the recent invasion that we had from the north during the Confederate War. And the government hauled off to southwest Little Rock and Old Washington. So that was the last time. But the other thing they did was, and this was a compromise that was made as well, that we would ask the people to vote to make us nonpartisan, that we would run not as Republicans and Democrats, but we would all run as independents. And I think that has a great perception of the people, right or wrong. The perception is if you run nonpartisan, you're not going to be beholden to one party or the other, and I think that's very, very important, the perception of the people. My own personal experience, Senator, is that when I came up for election in 2004, I had more people to talk to. And I was welcomed at both parties, the meetings. As you know, when you're running for office, you're looking for any group of people that you can talk to let them know who you are and try to convince them that you're the person that they should vote for. Very important process to you had more contact with people. So I thought it was great. I thought I was well received, and I think it's worked well. I think it's far better, if nothing else, the perception. I can tell you this. I don't doubt there's some instances where it's happened in some opinions, but my experience, and I was a trial judge for 22 years. I've been on the Supreme Court. This is my 13th year, and I've never seen any consideration given to a political party in a decision. I've never seen it. And I think that speaks well for our state. Although I think we've always been kind of, even when we had a one-party state, you saw the same. I think it had this. But yeah, I think it's been a very, very good thing. Any other questions? I know you were involved in that. So, any other questions? Yes.
What was the first case that you heard as a member of the Supreme Court?
Oh my. I don't know. I don't know. I don't remember. I do know this, and I'll talk to you when we get to that point about how we decide these cases, get the cases written. Because when you write an opinion after you make the decision, you have to satisfy. We say, and with a lot of reason, that any opinion that comes down, it may have Jim Hanna's name on it, but it's the court's opinion, and and so there's a lot of input from everybody. But being the new kid on the block, and I think that had a lot to do with it. I'd like to think that, maybe not. But it took me about 4 weeks to get the case down. I mean, they had questions, and I had to keep taking it back. But I don't remember what it was. I really don't. I'm sorry. I'm sorry. Any other questions? You might be interested. The question was asked earlier in the other meeting, how we decide cases. I was on the, like I said, I was a trial judge for 22 years, and I had no idea how our Supreme Court worked, how they decide their cases. I had a good friend that had been on the Supreme Court, and every once in a while something would slip about how they did business. And I know when I was first elected, my election was in November, and I was elected, and I thought, well, golly, I've got a couple of months here. I'll just go down there and sit in on them and see how it's done. They locked me out. I couldn't get in the conference room, and they said, you're not on the court, and nobody gets in here unless you're on the court. So I didn't. So I still hadn't been there. They did give me a little orientation how they do things. And after I got on the court, I'm one of those guys that's, when I was speaking to civic clubs, when asked to speak, and I think it's very important that we do that, and I think it's very important that the people understand and appreciate how we do business and how those decisions are made. As someone said, do you flip a coin? No. You can get in trouble for that. But our process, and I think it's an interesting process. It's unique. Other states do it differently, but it works well for us. You might say it's a fast track. But how we decide how the cases get to us, every Friday, our clerk, and he does a random assignment of the cases to what justice is going to be responsible primarily for what case. We never know what case we're going to get. And the only way, Friday, when they bring the cases up, and there'll be a stack, sometimes it's about like that, so there's a lot of reading, but that consists of a record and an abstract, which is, the record is a verbatim of what happened below. An abstract is where the lawyers have taken and turned it into a narrative form, which makes it a lot easier for us to read. It's a lot shorter of what happened below. And then you have your briefs. On that stack, on each case, there'll be a number. There'll be two numbers. If the number 1 is on top, that means since I'm the chief, I'm number 1. That's going to be my case. I'm going to be primarily responsible for it. If it has number 2 below that, my backup or check judge is going to be the judge with seniority, which is Justice Corbin. He'll be my backup. Now, every justice is fully prepared on every case that we have, and is fully prepared to write an opinion if he or she has to. On Thursday, we have our oral argument like we did today. We hand down our opinions. That's the first thing we did after I did the introductory. Those numbers and cases, those are our written opinions being handed down. After we finish conference, or the oral argument, we go into conference. We get in the conference room. Absolutely nobody gets in that room except the justices that are participating. If I've gotten recused, gotten out of the case for whatever reason, I have to leave the room. I can't participate in any way. Then the justice that has been primarily assigned that case, or primarily responsible for it, will give recite the facts, the issues, how each side is asking us to decide that, and then that justice will go on to explain how he or she would decide that case and why. Get it, and then you go to, that's without interruption. Then we go to the backup judge, whoever that might be, and that justice will say whatever they want to say about the case and how they would decide it. And sometimes it's lengthy, sometimes it's not. How they would decide the case. Again, we go around the table without interruption, and how they would decide the case. And after we finish that, it's open discussion. And as one of our justices has said, sometimes there's blood on the floor because there's obviously some core beliefs. There are differences, and that's the way it should be. It brings a lot of things to the table. Someone may think about something differently than I'd never thought about. So it's good, and hopefully we'll get the very best decision we possibly can in that particular case. After we get that, have completed that discussion. If it's my case, if I've got at least 3 justices agreeing with me, I'm going to write the opinion. If I don't, I have to make a decision whether I'm going to write the opinion like the court wants it, or give it to someone else to write. We do that with all the cases until we complete the cases that's been submitted. We will write the opinion, and on Tuesday at 1 o'clock usually, the next day we'll have the written opinion. We'll circulate to all the justices for them to review. Wednesday morning at 9:30 we'll have a conference, and the first thing we take up are those written opinions. And we'll discuss those written opinions. If everybody's in agreement with the written opinion, then it'll be handed down Thursday morning. That'll be the opinion. Any justice can hold that opinion for whatever reason. They may just want to think about it. If they disagree with it, they'll circulate by Tuesday at 1 o'clock the next week a dissent, which means I just don't agree with that. They may write what's called a concurrence, which means I agree with the decision, but I don't agree with how you got there. And this is what I think how it should be, how I would decide it. When that's done, we discuss and conference those written opinions, and a justice has a right to the following week to respond to that concurrence or dissent. Sometimes it goes back and forth for a while. But once we're in agreement, then the case is handed down, and that's what I'm saying. all the justices have some input, even though my name may be on it. It's really the court's decision. But that's kind of how we decide those cases. Yes, you've heard some of this, haven't you? Okay.
As Chief Justice, what are some of your other responsibilities? Do you serve as a sort of mediator and open discussions? What are your other responsibilities?
Well, one of the responsibilities in the is to run a meeting. Since I kind of chair it, as being the chief, and chair it and make sure the discussion moves and it doesn't get off and move it along. And oftentimes I try to help. And most of the justices do this as well, trying to see if we can't reach some kind of common ground as how they would decide it. That's an interesting question, and you haven't heard this part of it. But we do more than just read and write. The Supreme Court is charged with the responsibility of the licensing and the practice of law. We're responsible for that. That means the bar examination, the discipline, the continuing education. We also have various committees. We have one of the things that we do, we provide court interpreters when we have people that are deficient in the English language. We provide interpreters, certified interpreters. That's a program that we have, and it's growing and growing. And also signing. We also have some arbitration programs. So there's a myriad of things that we do. And the administrative function, I was somewhat amazed. After I was elected, I should have known. But I was at there's a conference that we have which consists of all the chief justices and chief judges of all the states and all the territories in the nation. And I was sitting there happy and dumb. The Chief Justice, Frank Williams from Rhode Island, was on the panel, and he just kind of casually said that he probably spent about 60% of his time on administrative matters. And I thought, how am I going to do this? Well, you do. And he was right. It's actually more than that I spend on administrative matters. But some of the other court members, they probably spend, well, I think when I was Associate Justice, probably 25% of my time on administrative. They help. I couldn't do it all by myself. We have various committees that do a lot of our work, which from the lawyers and the bar, and also lay people that make recommendations to the court. And they're also, they're liaisons with those committees. So, good question. We do a lot of things that are not, that it's not just reading and writing. Anything else? Yes.
I want to ask what support the judicial system react if the judges don't approve the law which has been passed by Congress legislation system. What it seems to be when you are learning the law in your college, if you disapprove or you just excise it, or you can take other basic, I don't know.
And that's a great question. It goes kind of back to what you were asked, a lot of times I don't like the law. I can't do anything about it because I don't have the authority to do it. But that's not the issue. The issue goes back as to what authority you have under the Constitution. The legislature, there's a lot of times they don't like some of the restrictions. They'd like to do something, but they're restricted to that, and they understand that, just like we do. We can
So just a high opinion.
all we can look to see is whether or not the legislature has exceeded the authority that's given to them under the Constitution. It doesn't happen very often. Now, there are times, I can tell you, that we see that there may be a gap that perhaps they haven't thought about, or that we'll send a suggestion that maybe they need to look at it. And that doesn't happen very often, but sometimes we do that, and they usually respond to that. But that's kind of the checks and balances that we have, legislature, executive, judicial, is all. We're restricted to what we can do. It's limited by the Constitution. Okay? You know, and having this checks and balance is what separates our country from other countries. The rule of law. You know, I've heard talks given by Stephen Breyer, who's on the Supreme Court, and others. Kind of the remarkable thing is that when you go back in our history, the tension, and you know, under our Constitution, there's supposed to be tension. There's supposed to be, and but you know, I can tell you, Thomas Jefferson was not a fan of the independent judiciary. He had trouble with it. He thought perhaps there was too much power being put in the power of being able to review. You saw Jackson obviously have some problems when they're trying to move the problems with the Cherokee Nation. I believe there's a case that came down and basically said, that's your rule, that's your opinion, now let's see you enforce it. You had Lincoln doing away with the Great Writ during wartime. Some things that you see going on during this time at different times. President Teddy Roosevelt and some of the things that he did. FDR packing the court, and you get down to reach the decisions that he wanted, and you get down to President Eisenhower and the case that came out of Little Rock, the integration case, and he basically just said, you know, the Supreme Court has ruled, that's the law, and we're going to enforce it. That's my job. That's a tremendous change, And it's a good thing that we've come that far. Having the rule of law, having the independent judiciary is what separates our country from other countries. And I've heard no less than a four-star general make the comment that if you look at the former Soviet Union, they had a great constitution, as good as ours. They had the protection of the rights just as good as our Constitution. The problem is they didn't have anybody to enforce it. They didn't have an independent judiciary. They had what's called telephone justice. Judges would get a telephone call from the executive branch how to handle a matter. That's not what we have. When the people start losing the trust and the confidence in their government, which is what happened, I think, and this is what the general was saying in the Soviet Union, because they had no protection of their rights, that's when the government begins to fall. Anytime the people lose their trust and confidence in their government, the government's going to fail. Any other questions? Yes.
You said out of the appeals that come to the Supreme Court, you said you reviewed about 18% of them, or how many is 18%?
Well, you're talking about from the Court of Appeals?
You said something about 18% that you...
Yeah, that's from, anything that ends in our court, there's going to be a written opinion on it, and we do that. In Court of Appeals, there's going to be a written opinion. Everybody's got a right to take an appeal, and we've been able to do that so far with the caseload that we have. What I was talking about is the Court of Appeals, when they decide a case, they issue the opinion. The people, if they're not happy with that, they can ask us. First of all, they'll ask them to reconsider. Then they can ask us within an 18-day period to look at it, to review it. And we'll get probably anywhere from 4 to 8 a week that we're reading their opinions and deciding whether we take them. And of those, there's probably it usually runs around 18% that we take. It's usually they have got off on something that was a case that's an issue's never been decided. That's usually where it goes.
So kind of pertaining to the argument that you had this morning, the oral argument, what about that case made you decide to review it?
Well, there's one reason. It's It's a death case. The man was, he was under the death penalty, and this is a what we call a post-conviction relief. He, they failed to file the 37 timely, and I think if you heard the argument, there was they want to get a hearing, basically send it back to look at to see whether or not he should be entitled to get to file that Rule 37, and that's what they're asking. But that's why we had it. It was a death case. And that, you heard some of the argument that death cases are handled a little bit differently with, and they are more, you've got a death that's involved. Any other questions?
If that's it, let's give him a hand. If I could, I know some of you have heard this already, but I want to comment and compliment, and he's heard me say this before, but not in public, but when a lot of times when justices or judges, when they're running for office, they're very limited as to what they can say or what they, and I know it's very frustrating. It's frustrating for the candidates because people are asking, they want to know as much as possible about who their candidates are and make the best choice possible who they want to be their judge or justice. And so I know it's very frustrating, but a lot of times they ask questions that the candidate just can't answer. That case may come before them. They shouldn't be in a position of prejudging in any way. And I remember very well back in 2000 when I was running, I was over here campaigning in Conway, and there was a young senator that was there, and they were asking some of these questions. And luckily, that senator understood the problem, the issues, and why, and he explained that to the people. And I never got another question. And Senator Baker, I'll never forget that, and how much I appreciate. And they responded to you. They trusted you. What I wanted to say. First of all, I appreciate being here and having the chance to talk to you, and hopefully we can do this again. This outreach program, and you might think about this as well with the lawyers that we're developing, having a real. This is part of the state of the judiciary that I talked about, that we need to be doing something, and we're going to be encouraging the lawyers and really the judges to be speaking to the classes, civic groups, and what have you, and we're going to try to develop some material on the rule of law so we can do a better job of explaining to people what it is that we do and how we do our work. I want to brag a little bit about our court. There are polls that you see of courts, and we see a lot of them. A lot of them come from the Chamber of Commerce, business-friendly courts, but there was a recent poll by the University of Chicago Law School, which is a very good law school, excellent law school, and a very conservative law school. They did a poll. They looked at all of the high courts of all the states and territories and rated them, ranked them. They looked at 4 different things. They looked at productivity, and I think if I've told you, we get in 75% of the cases within 2 weeks. We have a written opinion after the case has been submitted. No state does it that fast. Some states, 3 years it takes to get a case out. I know in Texas, 18 months. I mean, it just doesn't make any sense. Justices, when I talk around the country, they don't understand how we do this. And they talk about the quality of the opinions, perhaps suffering. Well, the other thing the law school looked at was the quality of those opinions that we write. And they also looked at the independence, whether or not the court favored one special interest group over another, and they looked at that. They also looked at how often other states look to the court for
guidance of how they would decide their cases. And some of you know, but you want to venture to guess where we ranked? Some of you heard something. Number 2. The only thing we fell down in is because we are a small state, that a lot of times, you know, the bigger states like California and New York, they have those complex business cases that they have, and that's where we, of the states were looking to us for guidance, that's where we fell down a little bit. But as one of the justices said, why are we so happy we should be number 1? Well, he's probably right. But this is a good court. They work hard, and although they're often wrong, in my opinion, they don't agree with me all the time. But that's the way it should be. Absolutely, that's the way it should be. We try to work together to get the best possible decision we can. Thank you so much for taking the time to be here.